Hello, and welcome to your video about your rental agreement. The purpose of this video is to give you a better understanding of your rental agreement, as well as to give you an idea of what you can expect from us as your property manager, and what we also expect from you as the resident. Now, I'm not going to read the entire lease agreement to you word for word. What I am going to do is go over and highlight many of the major points. So with that said, let's get started. Here we have page 1 of your rental agreement. Over here we have the date, we have the resident names. This will be the property that you're renting. Over here it says actual notice allowed by email. If that's the case, this box will be checked, and we'll go into that later in the rental agreement. Over here it will have one of your email addresses or phone numbers, or both in some cases. And down here is our contact information. This section of the rental agreement deals with your lease term, so if you have a beginning date and end date, that will be listed here. Or if you're on a month-to-month rental agreement, this box will be checked with your start date here. Your monthly rent charges will be specified in this section. Over here you have your rent payment. If there are any other reoccurring charges that you have on a monthly basis, they will be described here and listed here, which will give you your total monthly charges. Deposits, total deposit charged will be listed here. Deposit paid, which in many cases is going to be what you paid when you signed your execution agreement, will be listed here. However, in some cases, if that's not the case, we will list any outstanding deposit that's due. And in rare occasions, if the deposit is held by the actual owner of the property, we will check this box. Over in this section, we deal with fees for the rental agreement. Over here it talks about a lease break fee, and we'll get into that later in the agreement. Over here it talks about dishonored check fee. That means if you write a check to us and it doesn't clear, we will charge you $35 plus any bank charges. Over here we have a smoke alarm and carbon monoxide alarm tampering fee, which is $250. We'll go into that a little bit more, but basically if you disable either one of those alarms, you will be fined $250. And this is something we are very strict about because it's for your safety. Over here it talks about a late fee. If rent is paid late, we charge a flat amount, and that flat amount is 10% of your rent. Down here it talks about any prorated method in the agreement as far as how we prorate rent due if you're moving in or moving out at the mid-month or any other time. This is a section where you'll have any special provisions or disclosures. And in this section we'll list any other occupants, and over here we'll list any information about your vehicles. So that concludes page 1, and now let's move on to page 2. So here we have page 2. This section again highlights your smoke alarm and carbon monoxide alarms and indicates that you'll need to test them periodically to make sure that they work, and you're responsible for replacing any dead batteries. You're not allowed, again, to tamper with any of these smoke alarms or carbon monoxide detectors, including removing working batteries. Again, the fine is $250 for any such conduct. Down here we list your type of smoke alarm and type of carbon monoxide alarm. In the utility section, we list the owner and resident and indicate by checking these boxes who's responsible for which utilities. If you have a utility bill back agreement, this will be checked over here, and you'll have a separate addendum. Over here we're going to disclose any benefit other residents may receive from utilities you're paying for. Service charges for cable, etc. will be disclosed here. And if yard care is your responsibility or the owner's responsibility, that will be indicated here. So if it's your responsibility as the resident, you want to pay special attention to section 17 of the rental agreement. Over here we talk about animals. So in this case, if you have an approved pet for the property, then we would list that information here as well as on a separate addendum. Over here are other items that have been approved for use, meaning you've already asked permission and gotten approval. This is a waterbed, aquarium, or musical instruments. Over here, this box is checked if renter's insurance is required. We do require renter's insurance, so this box will be checked, and the minimum coverage will be $100,000 or greater depending on the type of property you're renting, but we'll give you that information. And over here will be your information about your insurance company and policy number. Over here, this indicates our smoking policy, so one of these boxes will be checked. In many cases, it's going to be smoking prohibited on the entire premises. Down here it talks about whether or not the property is located within a 100-year floodplain, and the appropriate box here will be checked. Here we're going to have all the resident signatures and dates. Here is where you're going to put someone to contact in the event of an emergency, and over here is where you're going to put information about in the event of death. Now, what we would need in this case is the person that is listed here cannot be a resident. And then down here you have our signature and date as well. So now we're going to get into the bulk of the rental agreement. Over here, section 1 deals with a variety of things. It indicates that your rent is due on the 1st, and rent is due, or considered, I should say, late after the 4th at midnight. If so, you'll have a late fee. We also cover here that we don't accept any partial payments of rent, we don't accept any third-party payments, and we also don't accept multiple checks from one household, unless you're paying online. But if you're not paying online, you have to not send in multiple checks. It also indicates that if you write a check to us and the check doesn't clear, again, that we can ask you to pay moving forward with only certified funds or a money order. And for those of you who are on month-to-month rental agreements, it indicates that we may increase your rent with 30 days notice. Over here, section 2 deals with what happens if rent isn't paid. We can send you either a 144-hour notice or a 72-hour notice, or in some cases we may send you both. Basically, those notices will indicate that rent must be paid by the specified date, and if not, your rental agreement would terminate. Section 3 here deals with applications of payment. Now, what this means is that if you were to send money to us and you owed us for other items outstanding like damages, repairs, utility costs, and so forth, it talks about how we would apply those payments. So it's really important to pay attention to that, because what you don't want to do is send us in what you think is going to be rent money and then us end up applying those funds differently. Now, we cannot deduct that money for a late fee or a non-compliance fee to make your rent payment late. However, if you owe money for other items, then we can apply those funds accordingly. So pay attention to the application of payment section. Over here it talks about, in section 4, early termination of lease. It discusses a variety of different things. What we do is we do actual damages, which is going to be discussed actually on page 3. So with that said, let's move on to page 3. Okay, so moving on to page 3. Now over here in page 3, it discusses what actual damages mean in the event you break your lease. This is a really important part because your responsibility when you break your lease does amount to quite a few charges. In this case, you could be responsible for any concessions we provided, lost rent, advertising and administrative costs, meaning the cost for us to release the property. Difference in new rent, so for example, if we're unable to rent the property again at the amount that we are renting it to you, then you'd be responsible for that difference. And also any concessions we have to give to re-rent the property. So the best thing to do is that if you ever are in a situation where you think you may have to break your lease, please contact our office as soon as possible so we can do everything we can to minimize these costs to you. Over here it talks about termination of month-to-month tenancy. If you have a month-to-month tenancy, then this would apply to you, obviously, meaning we would give you 30 days notice if it's within 1 year of your tenancy. If it's after that, then we would be giving you 60 days notice. Down below there, it talks about conversion of fixed-term tenancy. And what that has to do is that your lease will automatically roll over to a month-to-month rental agreement unless we terminate it and sign a new lease. And so it's important to keep in mind that your lease doesn't just end on the end date, it will actually roll over. However, we will contact you 60 days roughly prior to your lease ending to kind of discuss the new terms of the next lease, or if the property is going to be sold or maybe re-rented under different terms. Over here in section 7, we talk about pets, waterbeds, and musical instruments. Again, this is going to give you information about not having pets without permission. Waterbeds will require additional insurance, and if you have any musical instruments, that will require approval from us. In many cases, we're okay with musical instruments as long as they're not causing problems with neighbors. Over here in section 8, dealing with occupants, this covers quite a bit of information. Some of the highlights here are that the only people that are allowed to live in the property are the people that are listed on the lease. It also covers a guest policy that says, you can have somebody stay in the unit for 10 days in a row or 20 days in a 12-month period. But if you're going to have anybody stay beyond that, then you need to get permission from us. It also goes on and discusses that if you're on subsidized housing, if you do have somebody who's staying for an extended period of time, you would need to disclose if they're providing you any sort of income. Now we're going to go back up to page 3 and to section 9 here. Subletting, you're not allowed to sublet the unit without our permission. Section 10 here, and regarding to care of premises, has to do with general cleanliness of the property, making sure that it's free of debris and so forth. Also, you're responsible for any damage and uncleanliness beyond normal wear and tear. And another important provision of this section is that if there's ever a water stoppage or overflow, you are responsible for minimizing the damage. Otherwise, you could be responsible for the cost of those things that happen, such as water overflowing from the tub continuously or the toilets. We would definitely hold you accountable if that was something that you could have prevented. And then over here it also mentions that you're responsible for replacing light bulbs which fail during your tenancy. Section 11 deals with barbecues and fire pits. You're going to have to follow the fire code first off if you're going to be having a barbecue. Now keep in mind that many apartments may prohibit propane or charcoal barbecues, so you'll want to get special permission before using them, and you'll definitely want to look at the fire code. Exceptions to this would be electric style or hibachi style grills, that may have maybe electric or have 1-pound propane cylinders, and fire pits are prohibited at all times unless you get permission from us. Section 12 deals with use of and changes to the premises. Here we talk about using the property in a reasonable manner, meaning all the electrical systems, heating systems, and things like that. You're not allowed to discontinue or disconnect any of the utilities for the property that you're responsible for. And also, you're not allowed to make any changes or additions to the walls, ceilings, or windows without permission. So the best thing to do is, if you're not sure, contact us and get permission. Section 13 deals with damage. You're responsible for damage that happens at the property, and here you're agreeing not to damage or destroy the property. Section 14 deals with your security deposit. There's quite a few things that Section 14 here covers, and we'll follow it all the way up over here. And what this covers is that your security deposit is there to cover damage beyond normal wear and tear. Also, we will clean the carpets at your expense using your deposit when you move out, assuming that we've cleaned them prior to you moving in, or the carpets were replaced prior to you moving in, or if they were replaced during your tenancy. This section also indicates that when you do move out, that we will give you a final accounting within 31 days of you vacating. That also means we don't waive the right to add additional charges after the 31 days should we discover additional damages after we already mail out the final accounting. It also talks about interest-bearing account for the security deposit. Security deposits may be deposited into an interest-bearing account, and if so, we will be retaining all the interest. It also indicates information about what happens if the deposit is held by the owner, which we discussed briefly on page 1. And the final thing to consider too is that the deposit is returned to the last person who resides in the property. So if several people move into one household and during that time there's a change in the household, the actual deposit is not returned until the last person on the original rental agreement vacates the property. So that's really important to keep in mind. Over here, Section 15 deals with non-compliance fees. Non-compliance fees are fees that can be assessed or charged to you on your second and third offense. Some of these examples of non-compliance fees are late payment of utility, failure to clean up pet waste from an area other than the dwelling unit, failure to clean up garbage in an area other than the dwelling unit, parking violations, improper use of vehicle, smoking violation, or unauthorized pet. So if you have any of those things, then you will be charged a non-compliance fee. And again, this would be for your second and third offense. The fine for the second offense is $50. The fine for the third offense is $50 plus 5% of the rent. Section 16 here deals with joint responsibility, meaning that all parties are jointly responsible for the property. It also indicates that you will pay or reimburse us for any cost of repairs that resulted in damage that you'd be responsible for within 30 days. And it also indicates that if notice is given, or if you're in a rental agreement that allows for notice to be given, or like a 30-day notice, notice by one resident is considered notice for all, and in which case we could have any remaining residents requalify for the property. So here section 17 has to do with rights of access. This basically says that if we give you 24 hours notice, we're allowed to enter the property and that you will not withhold consent for us to access the property. It also indicates that in the event of an emergency, we don't need to provide 24 hours notice. And it also indicates here that if we're responsible for maintaining the yard, our contractors for maintaining that yard are allowed to enter the property without notice as long as it's during reasonable times. So with that said, now let's move on to page 4. Okay, so moving on to page 4 here. Here in section 18, we talk about if you're absent from the property, we'd like you to notify us if you're going to be gone for more than 7 days in a row, and that's when all parties are gone. This just helps us know what's going on in the event there's an emergency, so we would appreciate you providing us notice. Section 19 has to do with legal action. In the event there was a legal dispute between both parties here, it says that the prevailing party would be reimbursed attorney's fees and entitled to any additional costs that are reasonable. Section 20 deals with locks for the property. You really need to keep your door locked at all times, and we're not liable in the event you experience a loss because you didn't keep your door locked. It's also important to note that you're not allowed to change the locks without our permission. However, if you're in an emergency situation and you need to change the locks, you may, but you must provide us a new key immediately. Section 21 deals with renter's insurance. There's quite a few things to cover here. And here we indicate that renter's insurance, if required, which we do require it, what your responsibilities are, and as the owner what their responsibilities are. This means that we can ask you to provide proof of insurance prior to your occupancy. Also, you may request from the owner proof that they have insurance, and we may request proof that you have insurance from time to time to make sure that it's still current. In the event you don't insure your property or your policy lapses, you're not entitled to any of the agents or owners' insurance policies. So that's important to keep in mind. Section 22 has to do with conduct while at the property. This section covers a variety of things, one of them being you cannot have any commercial activity at the property. You're responsible for yourself and guests' conduct. It also discusses quiet hours between 10 p.m. and 7 a.m. where noise should not be able to be heard from neighbors or neighboring units. Residents are not also allowed to play in the hallways, stairways, entrances, except where permitted. There's no illegal substance use at the property or on the grounds. We also have the right to exclude certain people from the property if they've been a problem. In this case, we can trespass them off the property. If we have done that, then you're not allowed to have that person on at the property. And you're also not allowed to do anything that would endanger you or others at the property. Over here toward the top, we have section 23, which deals with malfunctions. If anything stops working at the property, you have an obligation to let us know. That's what we're here for. We're here to take care of anything that stops functioning. It's not going to be an issue if you submit a maintenance request. We're not going to get mad. Again, this is our job, is to maintain the property for you. So if you have anything at the property that's not working, please let us know. Section 24 deals with resident losses. This basically indicates that if you experience a loss due to lack of heat or refrigeration that arised out of an accident, an act of God, or something beyond the owner's control or our control, then we're not responsible for that. Section 25 deals with cosigners. Basically says that the guarantee must remain valid through the tenancy. If for any reason the guarantee by the cosigner did not remain valid, you'd be considered material violation of your lease. Section 26 deals with community rules. It talks about rules for the property that we've set out, and in this case we haven't set them out, then we would be using a particular addendum here, which will be a separate page that talks about rules and regulations for the community you live in. Section 27 has to do with written notices. Written notices talks about in the event we have to send you a notice about your lease, we would send that by first-class mail, and it also mentions other methods that we would deliver that notice. But the majority of the time, we're going to be sending you that notice, whether it's a violation for noncompliance, a late notice, or something like that. We would be sending that by U.S. mail, and again, that would be first-class mail. Over here, you have Section 28, which deals with actual notice. We discussed that a little bit earlier in the agreement. Actual notice is when we would give you notice for entering the property, for example, to do an inspection or something like that. This talks about the methods in which we can provide that actual notice. We can tell you verbally, we can leave you a message, we can post a notice if that's appropriate, we can send you a fax, we can send you something by first-class mail, or we can email you. Now, in many cases, we're going to be sending you an email, but we'll always call you unless we're doing a large maintenance issue. For example, if we're having gutters cleaned at all the properties that we manage. In that case, we'll send you just an email to provide notice. We won't be doing the phone call and email. But aside from issues like that, we really will be providing both. So let's scroll up to Section 29. 29 has to do with parking and use of vehicles. Basically, you have to follow all parking rules and signage that are applicable to your property. Section 30 deals with control of the common areas. Basically says that the owner, agent, or somebody that we designate as the person in charge is allowed to enforce control of the common areas, meaning if we've asked somebody to leave the property and they're not allowed to return, that party is allowed to enforce that aspect of the trespass notice. Over here we have Section 31 that deals with reasonable accommodations. If you need a reasonable accommodation, please feel free to make a request, and please specify the nature of that request. If you can do so, requests also can be made in writing, but that's not required. Section 32 has to do with termination for false information or criminal conviction, meaning if we find out that you lied or had incorrect information on your rental application, or if you've been convicted during your tenancy of a criminal conviction that we would prohibit, then we can terminate your rental agreement. Over here, Section 33 deals with rescreening. This says that in the event that you transfer to a different unit, the property changes ownership, maybe a management company changes, or every so often we're allowed to rescreen you as the resident to make sure that you are still able to qualify for the property. Now, Section 34 here is the final section of your lease agreement, and this is the complete agreement. It basically indicates that if it's not in any paperwork we're signing here along with your lease or subsequent addendums after we've entered into the agreement, then it doesn't count. So basically, all parties here are going to rely on what's been written in this agreement or any addendums and so forth, not any previous agreements or agreements, that have been done orally and so forth. So if you have any questions about your rental agreement, then this is the best place to look initially, or you're more than welcome to contact our office and we're happy to go over it with you. I hope this video has been helpful and given you a better understanding of your rental agreement. Thanks for watching.